Chapter 27, Jurisdictional Questions Conclusion. SS 405, Jurisdiction Beyond State Boundaries. A few miscellaneous observations will bring this branch of the discussion to a close. Creditors may be reminded that the courts of one state cannot entertain jurisdiction of an action to recover lands lying in another state where the proceeding is in rem, for actions for the recovery of real property, or for the determination of an interest therein, are local and must be brought in the state and county where the premises are situated, but where the court has jurisdiction of the proper parties. It may, by its judgment or decree, as we have seen, compel them to do equity in relation to lands located without its jurisdiction. The court in such case acts in personam, and may compel a specific performance of a contract for the sale of land beyond the borders of the state, or a conveyance of lands outside the state jurisdiction when the title has been fraudulently obtained by a defendant, and a debtor may be compelled to convey lands in another state for the benefit of creditors, so as to vest in the grantee the legal title. So the court has power to decree the cancellation of a void mortgage which is an apparent lien and clout upon property beyond the jurisdiction of the court. This power, says Johnson, J., has been frequently exercised to compel parties to perform their contracts specifically, and execute conveyances of lands in other states, and also to set aside fraudulent conveyances of lands in other states. 3. Where the necessary parties are before a court of equity. Said Swain, J., it is immaterial that the res of the controversy, whether it be real or personal property, is beyond the territorial jurisdiction of the tribunal. It has the power to compel the defendant to do all things necessary, according to the lex loci re citi, which he could do voluntarily, to give full effect to the decree against him. 4. Without regard to the situation of the subject matter, such courts consider the equities between the parties, and enforce obedience to their decrees by process in personam. SS 406, outside county of defendant's residence. In that case which arose in Georgia, it appeared that the Constitution and laws of that state required that suits must be brought in the county in which the defendant resided, and it was held that it was good ground of demur to a bill in equity to set aside a fraudulent conveyance of land that it was not filed in the county of the defendant's residence. The defect was held not to be cured by the fact that the bill was filed in the county where the land was situated, or because a lessee of the defendant in possession of the property was a party to the bill, when no substantial relief was sought against such tenant. This is exceptional practice. 4. At least so far as realty is concerned, the action to set aside a conveyance would be local, and local actions should be brought in the county where the land lies. SS 407. Appeal to United States Supreme Court uniting claims. When judgment creditors join in a suit to set aside a fraudulent conveyance by their debtor, and the amounts found due to the creditors respectively are less than the jurisdictional limit of the United States Supreme Court, the several claims cannot be united to give jurisdiction on appeal. And Seaver v. Bigelows, Nelson, J., said, the judgment creditors who have joined in this bill have separate and distinct interests depending upon separate and distinct judgments. In no event could the sum in dispute of either party exceed the amount of their judgment. The bill being dismissed, each fails in obtaining payment of his demands. If it had been sustained, and a decree rendered in their favor, it would only have been for the amount of the judgment of each. In Schwed v. Smith 5, the same court held that if the decree was several as to creditors, it was difficult to see why it was not also several as to their adversaries, the theory being that although the proceeding was in form but one suit, its legal effect was the same as though separate suits had been instituted on each of the separate causes of action. SS 407A, Certificate of Division. Whether a sale and delivery of a debtor's stock of goods, by way of preference of a bona fide creditor, is fraudulent against other creditors, involves a question of fact, depending upon all the circumstances, and cannot be referred to the United States Supreme Court by certificate of division of opinion. This closes the discussion concerning fraudulent conveyances and creditors' bills. We have traced the famous statute of Elizabeth from its enactment to the present time, and have seen how important the place it fills has become in our jurisprudence. The volume of litigation engendered by covenous alienations is scarcely creditable to the integrity of our people. The ability of the courts to successfully grapple with fraudulent debtors without the coercive aid of imprisonment frequently becomes a matter of grave doubt. Hence it is that the existence of cases accomplishing results like those of Cutting v. Cutting and Broadway Bank v. Adams is to be so deeply deplored, that the law regulating the remedies of creditors against covenous conveyances and for the conversion of equitable assets is developing in the right direction, and becoming more effectual against the debtor class. Must be conceded, it is still, however, in an unsatisfactory condition. the many forms in which a debtor's assets can be secreted or spirited away, and the endless varieties of fraudulent devices render the solution of the problem a matter of extreme difficulty. Time and experience alone can work out a satisfactory conclusion. The development must of necessity be in the courts. We doubt the ability of the legislative power to further materially progress this branch of our law.